Hi, everyone, and welcome to today's program, IP and Video Game Issues, Copyrights, Trademarks, and Patents. This program is brought to you by the ABA Young Lawyers Division's Intellectual Property and Internet Law Committee. My name is Michelle Mew. I'm one of the vice chairs of the ABA YLD IP Committee, and I'll also be serving as the moderator today. Joining us on our panel is Giselle Girones from Schulman Fugate and PLC from Jacksonville, Florida, Ben Hodges from Foster Pepper PLC from Seattle, Washington, and Yang Pern from NCSoft Bellevue, Washington. So we can get started today. Yan, do you want to go ahead and get started with your presentation?
Yeah. So, the video game industry is really cool because video games draw on both technology and creativity, both of which are protected by IP. And when you think about all the different relationships between these tech and creativity elements, like the art, the sounds, the code that allows the user to interact with all of these elements, and additionally, the people who create those elements, it's really all about licensing. And 50% or more of what I do is reviewing, drafting, negotiating these contracts, and really trying to understand what IP the parties are exchanging or creating and how I should clearly capture that into words. And so for this first slide, I've created kind of a simplistic diagram, but it really shows you some of the different relationships between the video game components and the video game industry players that typically require some sort of licensing agreement between them. So we have the developer who really creates the game, and in order to do that, you see the other bubbles around it, kind of the code, the artwork, the other elements that I touched upon. And the developer needs to ensure that each of these creators has a license or more likely an assignment agreement so that the studio truly owns all that IP and ultimately owns the game. Next is the publisher who really takes the game to market, advertises it, and really to do so, the publisher needs a license agreement from the developer, a license of the game in order to do those things like advertise or work with distributors like Xbox or PS4 to really release those games to the consumer. And when you think about the consumer too, when you purchase a game, you're not really buying the IP. Instead, it's really a license agreement. The video game company is giving you permission to download, play, and enjoy the game. And there's other things too, like between a consumer and a publisher, when the consumer wants to dress up like a character during cosplay or create fan art, those are all license agreements that govern that relationship. And one kind of bubble that I hadn't thought about in this ecosystem is really just other third parties. So recently I had a request come in about a third party wanting to use our video game music in concert and product demos. And so I worked with our outside counsel to really prepare those music licenses. So, it is a kind of a fun ecosystem. And when you think about it, again, it's all governed by licensing. So if we go to the next slide, this kind of covers all the different provisions that typically are negotiated or can go into a licensing agreement. Things like ownership, duration, scope, all of these things I kind of touched upon substantially in the previous slide, and so I won't go through each one of these, but happy to answer any questions later. So moving on to the next slide, we kind of get into the more interesting video game IP, including character design, and what we run into is making sure we're not infringing upon other people's right of publicities or other copyright owners' works. So on the left side, you see, some of you may know about kind of the Lindsay Lohan versus Take-Two litigation. So what we have here is Take-Two is the video game company that created Grand Theft Auto, and Lindsay Lohan filed a lawsuit alleging that she and her image was used as a character without her permission. The results are quite recent, and what the court said was that there was no claim of right of publicity here because the character, you see, this woman in a bikini with her cell phone, did not have the characteristics that were uniquely identifiable or attributable to Lindsay Lohan. Instead, it was just a generic depiction of a young woman. And so that's kind of one example of right of publicity. And so when it's a real person, we have right of publicity. When it's a fictional character, like here Scarface or James Bond or The Walking Dead, that's protected by copyright. And the Scarface images I just kind of pulled from Google, and I think that the video game is an actual adaptation on Scarface, and so here I'm sure they obtained the necessary licenses to create this adaptation based on the movie. So for the next slide, I kind of wanted to run through quickly, what right of publicity covered. And generally speaking, it's the person's right to control the way his or her, identifiable characteristics are being used by others for commercial gain. So generally, this includes name, voice, image, catchphrases, and sometimes there's, likeness, which is a broad catch-all. So in the image you see on the left, there's, Vanna White in the famous game show, Wheel of Fortune. And then on the right side, there's a Samsung ad. And so, here in the ad, you see a robot who's featured as Vanna White, is dressed like her, is turning letters on the game board. And the court found that this was enough for Vanna White to have a successful right of publicity claim. So, I think right of publicity is a very interesting area, and is very fun. And what makes it more interesting is that right of publicity is governed by state law. So you can imagine a state like California with the Hollywood industry. There's very, very protective rights for right of publicity, and it extends beyond death. Versus New York, which is actually where Lindsay Lohan files her case, has much less protections, and right of publicity does not extend beyond death. And what makes it even a little bit more complicated is that in video games, we run into the intersection of the protections of right of publicity, copyright, but also First Amendment free speech. So video games are a type of expression, is protected by free speech, and therefore in certain instances, like a critique or a parody, the First Amendment can trump right of publicity and copyright. So it brings us to copyright, another large area of video game IP. And Giselle will go into copyright in much more detail, so I just want to briefly cover kind of an interesting incident that came up. So copyright protects the way things are expressed, not the concept or idea itself. And so oftentimes the game plot and the game concept is not protectable, but the artwork or the dialogue within a video game is protectable. So a really successful and popular game right now, PlayerUnknown's Battleground, PUBG, filed a lawsuit against another competitor saying, for copyright infringement. And some of the claims that they raised, are what I kind of reproduced here. So the frying pan, that's a weapon in Battlegrounds, you see that, same art and concept in the competitor video game. Similarly, there's the, virtual world environment, and as the player is descending, one of that scenery is an area with many shipping containers. And so you kind of, it's interesting when you look at this kind of complaint because copyright protects the expression, and so therefore, a lot of the claims are grounded in these art assets, as opposed to saying, well, this competitor copied this game plot or this concept, because those things are not protectable by copyright. On the next slide, another large area that's definitely not new and could possibly be, its own webinar is user-generated content. So we know that the game is owned by the video game company, but if the player gets to create an avatar, maybe a backstory for their avatar, buildings and maps, who owns that stuff? And so from case law, we know that user-generated content, can be IP, and it can be infringing if it's deemed a derivative work, because that's one of the exclusive rights that a copywriter has. And so when you're creating a map that's really drawing upon the game's underlying story, the setting, and the characters, that could be seen as infringing derivative work. But because this area is a little bit, I guess it can get really messy if it's not clearly, I guess if the relationship is not clearly expressed or understood. So oftentimes it's governed by the EULA, so the end user license agreement. It's purely contractual. Oftentimes we also have content usage rules for things like fan artwork or fan plushies. What are the guidelines on how end users can use this content and who owns it? So moving on to the next slide, I wanted to touch upon this interesting case just because I moved over in-house recently, and as I was preparing this, I came across kind of a case that involved our company. So here it has kind of a different variation on user-generated content. So when the user is potentially able to create their content that could be infringing on other parties, who is ultimately responsible for that infringement? So here, NCSoft created a game called City of Heroes, which is a massively multiplayer online role-playing game. And so when you create your avatar, you can create your own costume, you create gender and looks. And so Marvel, claimed that a lot of the users were creating superheroes that reflected their copyright and their trademarks. And so, ultimately, this was a good outcome for NCSoft because the court found that the game itself has substantial non-infringing use. And because this game is not a tool solely for infringement, the video game company is not liable. This kind of concept kind of goes back to an older famous Supreme Court case about Betamax, where Universal Studios sued Sony because Sony came up with this VHS recording home system, and obviously a lot of home users were filming and recording a lot of these movies. So finally, kind of one really interesting area that I was able to practice in when I was in private practice, on the next slide, is kind of the esports industry. So as the esports industry became kind of more mature and really focused on protecting their IP, I got to work on things like creating patents for streaming technology, ensuring that companies who are coming up with tournament organizing software truly transferred the IP from each of those owners into the company. Similarly, like analytics, coaches and analysts being employed onto these esports teams wanted to ensure that their methodology, their databases that they created would not automatically be owned by the company just because they were being employed by them. Instead, they wanted to really carve that out and say that that was my pre-existing IP, and if I were to leave the team, I would still be able to utilize that analysis and methodology. We kind of covered in the crazy diagram that I had created. When we have tournaments, we typically have casters and hosts, and we need a license and release from those folks in order to use their likeness, their voice, their image in our streams and in kind of our ads. One thing about esports that kind of came up is kind of a unique dispute that arose because of this new industry, esports, a new kind of streaming and broadcasting platform like Twitch and Azubu, that resulted in a very interesting copyright case. So the dispute centered around, there's a very famous game called League of Legends, and one of the most famous professional players, his name is Faker. So under Riot's blanket IP license, Faker is able to live stream his personal practices, on whatever platform. And because Faker was so famous, whenever he streamed kind of his matches and his gameplay, there would be so many viewers and so much subscription revenue that Azubu, one streaming platform, negotiated and signed an exclusive streaming deal with Faker. And so the dispute arose when a channel on Twitch, a competitor streaming platform, had someone called Spectate Faker, who was also streaming Faker's gameplay. So Zubu filed a DMCA takedown notice with Twitch to remove that stream. And that seems like that makes sense. Faker has unique gameplay content. Azubu signed an exclusive deal to own that gameplay content, and therefore, if someone is streaming that gameplay on Twitch, Azubu should be able to remove it. It's kind of like NBC and Fox. If you have a broadcast or a show on NBC, you're not going to see it on Fox. However, what kind of made this interesting is in League of Legends, there is a tool called spectate mode. And so this particular person, Spectate Faker, was not just grabbing the content and restreaming it on Twitch. Instead, he was utilizing that tool in spectate mode and then streaming his own screen onto Twitch. And so, this became an interesting question of, does Azubu own the content that Spectate Faker is streaming? By what means can Azubu, stop other people from utilizing kind of a mode that is permissible in the game and stopping them from streaming, their own screen? So ultimately, Riot came out and issued a statement. So under Riot's, again, terms of service, it clearly says that no one owns, you do not own any gaming assets. So Faker did not own kind of that content because that's still owned by Riot, and therefore Azubu did not own that content. And ultimately, Riot did step in. Faker stated that he felt like Spectate Faker was damaging his brand, and because Riot did own that content, Riot was able to get that taken down. If there's any questions about this, I'm happy to answer, just because this is such an interesting and fascinating area, and I've kind of worked in it so much that sometimes I can just gloss over certain things. But I do know the next presenter will go more into copyright and streaming and can answer other questions as well. Thank you.
Great. Thank you so much, Yan. It certainly is an interesting area in the issues that you handle. We can go on to Giselle, and she'll go more into copyright and trademark considerations in relation to video games.
Thanks. And so starting off with trademarks, one of the big issues, aside from trademarking video game names, is the use of real-life trademark products in games. And so the Mil-Spec Monkey case that's on the screen right now dealt with the Call of Duty games, specifically the Call of Duty Ghost game, and the Angry Monkey trademark, which is Mil-Spec's trademark, is one of the most popular morale patches that the company promotes. And they filed a copyright and trademark infringement suit against Activision, claiming that in the game, the mark was being used as a patch that players could select to place on their avatars' uniforms and kind of customize them that way. And it also appeared in a promotional trailer for about 2 seconds, along with other patches. And so Activision argued that it was protected by the First Amendment, and the court actually found for them, finding that the Call of Duty game was an expressive work and that the design bore some artistic relevance to the game and was not misleading as to the source of the mark. So the court, went into an analysis, and it had been established that video games are expressive works that are entitled to First Amendment protection, and it cited the NovaLogic case, which was also an Activision Blizzard case from the Central District of California in 2013, and that one dealt with the Modern Warfare 3 game and a Delta Force trademark. And so there, the court, kind of analogizing to this case, found that the game's narrative and the music and how the players interacted and the fact that the players could control the fate of, their characters rendered it worthy of First Amendment protection. And so Mil-Spec tried to argue that their mark wasn't famous enough for this to apply, but then the court cited the ESS Entertainment case, which was a Ninth Circuit decision that dealt with the Grand Theft Auto game and its depiction of a real-life strip club titled Playpen, and in the game it was called Pigpen. And it noted that, it was still afforded First Amendment protection, even though it was not a cultural icon. So the test it established was the Roger versus Grimaldi test from the Second Circuit that had been adopted in the Ninth Circuit, and it found that artistic works used of a mark would otherwise violate the act, were not actionable unless the use of the mark had no artistic relevance to the underlying work or had some artistic relevance but explicitly misled the source or the content of the work. So basically the test, is pretty easy to kind of meet. You just have to have some kind of relevance above zero. And so the court felt that the Activision Blizzard had met this test sufficiently. And so moving on to the next slide, as Yen discussed, there's a lot of copyright and streaming issues that come up, and Twitch and YouTube command a large part of the internet traffic, and a recent study found that the streaming game content will generate about $3.5 billion in revenue by 2021. So it's obviously a big deal, and game developers have been apparently pretty lenient with allowing YouTubers and people on Twitch to violate their rights. So, and that might be because it drives sales and generates publicity. But developers have user license agreements, like Yen mentioned, that condition the streaming. So Blizzard's policy, it allows video production so long as the video is available free of charge. And then Bethesda kind of has the same, but it reserves the right to take down videos, for really any reason. So there have been some technological advancements to help monitor this. Twitch has partnered with Audible Magic to detect copyrighted content. Nintendo has partnered with YouTube to use their content ID system to flag content that is copyrighted. And there's obviously licensing agreements between the platforms as well. So one of the arguments that, as far as the streamers might go, is the fair use argument, but that tends to be an uphill battle because they are, commercializing their use. And so it has become more competitive between them, and it might be up to the platforms to kind of find a happy medium between kind of the success of Netflix and avoiding pitfalls such as Napster. And then moving on to the next slide. So privacy and biometric issues, it doesn't really fall squarely between copyright and trademark issues, but it's definitely an issue that has been coming up more recently. And the Take-Two case out of the Second Circuit is an excellent example of, kind of what companies should do and just what they should keep in mind as far as putting into their ULA agreements. So the Take-Two case dealt with the NBA 2K or 2015 and 2016 games, which used a face scanning feature that allowed the players to create avatars, and the video game would use cameras connected to the platform to scan, someone's face and head, and then it would use that to create their custom avatar. And so when a gamer wanted to use that feature, the terms and conditions would come up, and it would say that their face scan was visible to other players, they would be recorded, and basically it gave them a link to another agreement. So the court found that the plaintiffs did not have standing to sue, but it also found that they didn't really have a claim because they had been adequately warned about what information was going to be stored. There was an issue about whether they knew how long the information was going to be stored, but the court, the plaintiffs didn't really allege any harm, and so the court wasn't swayed by that. But basically, the key point to take away is that, companies should have security measures in place and should include in their privacy policy the ways in how they're keeping this information secure, and then provide an adequate description of what the information they're collecting is. And of course, I'd be happy to answer any questions about any of these topics in more detail after Ben's done presenting.
Great, thank you so much, Giselle. Now we can move on to Ben. He's going to give us a more patent perspective and its relation to video games. Ben?
Thank you very much, Michelle. So patents in video games are a little bit more complicated because they're more narrow, and frankly in the US right now, they're a little bit harder. It's not possible to get a patent on all aspects of a video game. You can't patent the concept behind a video game. You can patent certain aspects of it, but because it's software, the advent of 101 jurisprudence analysis case law has certainly put a damper on trying to litigate that. It's very debatable whether or not any such patents would actually survive assertion, and that's why I think you've seen kind of a slowdown in that type of activity. Now, this is in the U.S. In foreign jurisdictions, the case law and the rules regarding software patents are very different. And so I think you have seen an increase in both patent filings and some protection efforts abroad, not in the U.S., in response to that. But that being said, that hasn't stopped a lot of video game companies, especially the larger companies, from going ahead and patenting, because what you can get out of the patent office might not necessarily be the same thing as what you could use in court. So a lot of the companies are still actively patenting aspects of their games, and either through caution or through maybe seeing if the jurisprudence changes on that, they're a little bit hoarding of the assets. On the next slide is one of the examples of that, which is actually a rate. You wouldn't know it from the cover page or from the very basic flow chart, which a lot of you will recognize as pretty standard for software type patents. But this is actually a racing patent. So this deals with racing games in particular. And if any of you have ever watched a car race, NASCAR, IndyCar, or whatever, you know that if there's a wreck, there's a yellow flag that comes out, or a caution flag. None of the cars can pass each other. They just stay in one line. Now, this particular patent is in response to the fact that gamers like their games to be as realistic as possible. However, gamers also like excitement, and no one passing and every car staying in one line as it goes around doesn't exactly fit the bill for excitement. So this patent, if you ever get curious and want to go look at the claims, basically says we will randomly generate some caution, some yellow flag scenarios. It'll display the statistics at the start of that, where all the cars are, and then it'll also give you a chance to say, I want to fast forward through this, and instead of waiting while all the cars go around, just tell me what the position of everyone will be. Did cars take a pit stop, anything like that, at the end of the condition, the caution condition, and let me fast forward to that. And so this, I don't know, we could certainly make a debate whether this one in particular seems to be susceptible to an Alice challenge if it ever got asserted, but it is out there. The next slide is another interesting patent, this one coming from the massively online multiplayer games. this one deals with creating dynamic content for NPC, non-player controlled characters. So this patent, again, I don't know whether or not it would survive a challenge, but it is based on the idea that it's nice if the NPCs have some dynamic content and aren't the same thing every time. So this particular studio filed a patent on it, and it did issue in 2012. This one, I think, might actually be a little bit more survivable in an Alice challenge. It is very much a software patent, but it does, I think, arguably deal with a very technologically computer unique problem and solves it in a unique way. It might still be susceptible, as all software patents are, to a 101 challenge. It also, if you read the spec and you read the claims, does pose another interesting problem of 112. Is there enough written description in this particular patent to actually survive? I'm not sure. I mean, it is a good example of the dangers of trying to patent in this realm. But you both have to survive 101, and now you need to provide enough written description support for how this is being done. And a lot of these patents are not that long, so their specification may just not contain enough detail about how to do it. There's another patent that I didn't have on here, but is worth looking up if you're just curious, and that is patent number 8082499, also owned by EA. You'll notice that one of the other ones was also owned by EA, so EA is active in this field, and the 499 is actually on the dialogue wheel in the Mass Effect games. So presenting dialogue options in that particular manner. Again, I don't know how bulletproof that would be if anyone tried to assert it, but it's out there. So the next slide is we've talked about, what I've been talking about is utility patents on aspects of the gameplay, but that's the hardest part of the IP or the patent process for video games. Another option is patenting the actual devices. So consoles and devices, it's a lot easier to do. The Nintendo Switch right now, I actually think, has 2 active lawsuits from smaller companies based upon how you can use the Switch and the specific configuration of the controllers on the outside and taking it apart. So that's an actual device. It's a thing you can hold in your hands, and it's how it functions. And so it is a much easier thing to patent nowadays than the games themselves. Another patent that has existed in the past on these is haptic controllers. So the vibration and the feedback that you can get in controllers, that was a patented aspect too. And again, that was an actual thing. It was making your controller vibrate. It's something you could hold in your hands, and so it wasn't really a 101 type issue. Design patents are also very much available on the consoles and the devices. The consoles themselves and the controllers, they have a utility, they have a function, but their particular form, the choices that the company's made to put them in the particular shapes they have, are not usually very functional. The one exception to that might be, racing wheels, but beyond that, the controller itself, the way that it's shaped, doesn't have a particular function usually, and so those exact choices can and often are design patented to prevent people from taking the exact look of your console and your controller and taking it off. Another more recent advent in the video game industry is on network patents. So as video games have become, even on consoles, become less just in your house, playing it with you or your friends, and have moved into an online ecosystem for playing, patents on that network have become more prevalent. So some of the patents here are on the underlying architecture of the network, so how the consoles interact with each other, how the information is stored. Again, these are possibly not the most litigation-friendly patents in the world right now, with 101 challenges and 112 challenges, but there are a fair amount of them out there, both for Xbox, for Sony, for software, for computer video games. All that is out there. There's also some unique things like user rewards. So the ranking systems and rewards that you can get for playing more, there are some patents out there on that, about how do we basically encourage or reward players for using our network more often. And so there have been a few patents issued on that, which is, again, potentially a 101 challenge. People have been getting awards and trophies for a very long time, putting it online. I don't know if it survives, but the patents have been issued. So if you go to the next slide, moving beyond patents, I wanted to briefly address one of the other topics that hasn't been addressed today, which is trade secrets. So this is something that a lot of patent practitioners have encountered when clients come to us to say, should I patent this particular aspect? Should I copyright it? And we have to figure out, given the current state of the law, is it worth public disclosure of how you do things, or should it be kept as a trade secret within the company? So the same general rules apply in the video game concept as for any discussion of that. The positives are trade secrets are cheaper. You don't have to file an application. You don't have to fight about it to get it through the patent office. It could last forever. It doesn't, as long as you keep it secret, no one can take it, and you don't have to disclose how you do it. So if you think that you have this really nice inventive concept behind your game or behind a particular aspect of the game, but you don't want to tell people how it's done, for them to either steal it and then dare you to challenge them in court, or try to make enough small tweaks to it but use yours as a starting base that it wouldn't infringe, you don't have to give them that head start. The negatives of it, especially in the video game world, if it can be reverse engineered, you can just copy it exactly. And a lot of games, especially some of the online games, could be relatively easy access to the code behind it, or how it works. You have to put into place some complicated internal protections to keep your trade secret. And then, of course, it's harder to prove infringement, because just because someone is doing it the same way that you have done it, not a patent, you don't get to stop people from copying you. You only get to stop them from stealing your trade secret. So if they manage to reverse engineer it, they can do it. And so to prove infringement, it becomes a little bit harder. Some examples of some trade secrets, or some general aspects of trade secrets that people have kept, are the code, although again, that a lot of people do choose to copyright that instead. Network architecture, there are some patents on it. There are some choices that have been made to try to keep the architecture as a trade secret as well. But then the most common of the trade secrets in this realm right now are subscriber lists. So just how any business values their customer list and making sure that no one else has access to it, especially in the online game realm, with subscribers that pay monthly fees or however they have set it up. Those lists of subscribers are very much kept trade secret, because one company knows that if they are willing to pay someone else's monthly fee, they are much more likely to also be willing to pay another one and another from a competing company. Those are the people that are willing to keep paying that on a regular basis are the most sought after. And so the subscriber lists are kept very much as a trade secret, and very much valued by the companies. So if we go to the next slide, wanted to talk briefly about another general realm of video game protection, which is app-specific issues. So we've talked a little bit about the traditional console games. We've talked a little bit about online gameplay with more traditional computer games. But with the advent of mobile gaming and mobile apps, you have a whole different realm of protection and issues that arise. Most apps are not distributed directly in most games in general, are not distributed directly by the developers. And so, especially with the Google Play Store and the Apple App Store, there is usually a distribution agreement that goes to the developer or the owner of the game. It's usually a click-through agreement. Obviously, Apple has a lot more power in that realm than the developer does, and you don't have a lot of other choices. You really have just two main choices, and if you're a developer, you can't really negotiate against them. So it's really a click-through that they usually just have to accept. And the interesting part for IP is that click-through agreement usually contains an indemnity or warranty on IP that whatever the game that you just put into the App Store doesn't infringe on anyone's IP. And so if for some reason there is an IP suit related to this and Apple gets hit or someone else gets hit that's subject to this, the developers are indemnifying and warrantying that that's not going to happen. They're going to have to step into their place. Now, whether or not most of the developers are well funded enough to actually take that on is a second issue that the distributors have to really take into account when these suits happen, because a lot of them might not trust, if it's a solo developer that just developed this and put it on, you're not really going to be able to trust that they're going to be able to have the cash flow to defend that case, but they are potentially liable. So another issue that arises in the app world is the developers. So developers in the app companies especially are a lot more mobile. They move companies a lot more than in the traditional spaces. And so when they're moving between companies, often you have ownership issues, you have copying issues. A lot of times an engineer will change companies, and you'll see very coincidentally the new company develops a game or a application that seems to be very similar to what they were working on before. And sometimes that's deliberate, and sometimes that's just the developers not realizing that they don't own their own rights to it. And so you've had some very large companies, some of the major players have actually gotten in trouble with either games or other apps that they didn't even realize that this engineer they hired then developed, quote unquote, developed a new app for them or a new piece of software that just they didn't realize they'd been working on someplace else. And so you have some issues that have arisen from that. One of the other things that apps in particular are susceptible both for patent and for copyright is they're a lot easier to pirate. Their code behind them, the concepts behind them, just by nature of how much memory is involved in running these, are much smaller software behind it. And so when you jailbreak, there's some issues of jailbroken phones and getting access to games for free, and there's issues with being able to get access to the code in a much smaller space because you don't need as much code. So it becomes a lot easier to pirate and also easier to copy, whether it is a deliberate pirating or just looking at the game and saying, this isn't that complicated, I can develop my own. Of course, the Flappy Birds case from a few years ago is a good example of how easy these things are to develop and how easy they are to copy. It's just makes it more complicated in the IP space because you have a game that's a lot easier to develop than it was 10, 15 years ago, 20 years ago for the large game houses. Now, there hasn't been as many app-related lawsuits, in part because 101 has slowed down all of these things, and the app games really started taking off around the same time as the jurisprudence became stricter. But there are a couple notable exceptions. Zynga has more than a few lawsuits out there, on both sides of this issue. But beyond that, the space is still relatively quiet. And so with that, again, if any questions remain for myself or any of the panelists, I'll turn it back over to Michelle.
Great, thank you so much, Ben. I just wanted to remind the attendees that you can submit your questions via the question component of the GoToWebinar section. It looks like we have a few questions that have come in during our time here of the webinar, and I can go ahead and address those. And I'll go with the first one. Yan, I think this one is more directed towards you. So the question is, regarding the Twitch esport issue, they're assuming that it applies to We Play gamers on YouTube. Would they be protected as creating original content through their commentary?
And sorry, what is, I guess I'm not familiar with We Play, but I guess, maybe that's irrelevant to the question. I think, Giselle kind of touched upon, so for a lot of these YouTube streamers, they do own the content because they, are creating something original. There's creativity, and therefore copyright automatically attaches. But because they are using the platform of YouTube, it becomes a larger question of what is the contract between YouTube and that, individual influencer or streamer. And I think Giselle kind of touched upon, there are a lot of different licensing arrangements, agreements that once you post content on YouTube that people can freely share. And so I think, the first part of the question is yes, when there's a new creation, a new content, there is ownership attached to that, but it can be negotiated and altered between the two parties.
Okay, great. We only have a couple of minutes for some other questions. I'll see if we can get through them. Ben, I think this one may relate to you. Could you comment on copyright aspects of computer code related to trade secrets and the comment that the code could be copied exactly?
Well, if you've submitted it to the Copyright Office and gotten a copyright on it, you've publicly disclosed it because you've had to give a sample of it to the Copyright Office to say what's been copyrighted. Now, admittedly, that's not the full code usually. It's a excerpt from it, so you could potentially still have an argument there. But that is the danger of trade secret versus copyright, and the same thing with patent. If you have to get your monopoly on it in any of those situations, you do have to have a level of public disclosure that it's hard to have trade secret coexist with, because once you have publicly disclosed it, you no longer can claim a trade secret in it. So that's always, I think, if I'm understanding the question right, that's always the discussion you have to have with a client is how much do they want the monopoly rights in it, and as a result you publicly disclose, versus how much do you want to prevent others from having that head start of seeing what yours is, because you can design around a copyright, you can design around a patent, you can make enough changes that it's no longer infringing. And so that's always the danger that we have to have the discussion with our clients.
Okay, great. Thanks so much, Ben. I think we have one last question. How do you determine the value of IP assets, and how does an asset's value influence your practice, both in litigation and contractual context?
So I'll jump in on this one because it's actually a very fun conversation that I've had to have. I value them based upon quality personally. And so when I have clients that are coming to me in a acquisition scenario or a selling scenario, or wanting to reach a point of selling, I always talk about how not, especially in the patent realm, not all patents are created equal. Right now with 101 and 112, you have a lot of patents out there that while you technically have a patent, it might be functionally useless in stopping anyone because it'll never survive litigation. So that's how I personally value them. I look at whether or not they are usable. However, with the large caveat of that's how I personally value them. However, I also know a very large amount of um, some of the investment space out there doesn't value them. They in that particular way. They just look at them as if they exist, they attach a value to them. Because I and some of my colleagues, both at my firm and other firms, have been contacted after an acquisition and said, "Hey, I've got this patent or I've got this copyright. Can you tell me, what it is?" And they haven't done that due diligence before, so all they're doing before the acquisition, when they're trying to attach a value at them, is seeing have they issued, do they exist, and if they do, they just give them a blanket value. And so I think the more savvy investors are looking to the content and the quality of the IP, but a lot of investors out there don't yet.
Okay, great. I think that is all the time that we have for questions today. I really want to thank our panelists, Giselle, Ben, and Yan, for sharing your knowledge and also for the attendees' participation today. Thank you so much, everyone, and hope you have a great day.